No.
Give memos. Monday it will be. Give memos. Give memos.
One submission, please. Serial number 42, my lord. Admission matter, serial number 42, my lord. We'll take up next week, please, ma'am.
76, 78 all right one.
But serial number 42, please, ma'am.
My lordship, serial number 89.
Wait.
Adjournment will be called up. Almost 35 to 45.
My lord, serial number 42, please, my lord.
Serial number?
Serial number 42, my lord. I have informed the other side, my lord. It will be taken up next week, please, my lord.
42.
With your lordship permission.
Serial number
42.
Collected matter. My lord, interim order may be extended till then.
Request made by the Lana Council appealing for the petitioner. In serial number 324 of 2021.
Interim order may be extended till next date, my lord, please.
Friday.
My serial number 42, please. My
Your
interim
lordship-
order may be till then. Interim order may be extended.
23rd.
Serial number 88, my lords.
Wait,
Sir,
sir.
please wait, sir. Serial number 43 to 51.
50.
Your lordship.
Your part? Let us, we will see. Huh? Let us, we will be. What objection you? What you will say now? You tell me what objection you will say. I know the facts. You tell me what objection. Now let us, will see.
In about 52 to 62.
53. Your part there? Wait.
About 53 to 57.
Your lords, I'm appearing in serial number 64, your lord.
65. At the request made by the Lana Council appealing for the respondent 1 to 5. This next week.
Your lords, appearing in serial number 64, your lords.
64, sir.
Yes, your lords. I'm for the petitioner in this case, your lords. I'm not keeping well. I'm unable to come to the court, your lords. 2 week time may be granted. An interim order is granted earlier, your lords.
Brother only, no. He is not keeping well. Where may be? Leave at all. So that the request made by the Lana Council appealing for the petitioner, stating that he is not keeping well. List this matter one date for him next week.
And interim order may be extended, your lords.
Interim order granted earlier, extended till next set of hearing. Next week,
Much
get
obliged.
ready.
Yes, your lord. Yes, your lord. Much obliged.
73. 68 to 73. 74 to 82.
No, it's 21 matter preliminary. Already no, date is given today. You see the call list. No, it is today. Date is also given. Okay, today I will give it. So,
Number 82.
82, sir. Your, at the request made by the Lana Council appealing for the petitioner, this next week. Next week.
Your lordship, serial number 88, man.
80? 82, sir. 83 at the request made by the Lana Council appealing for the petitioner list after 2 weeks. 80?
My lord.
88, my lord. 88.
Your part?
Serial
Your
number
part?
88, my lord.
Song week. At the request
Yes, my
made by
lord.
the
2 weeks, if your lordships may consider.
list after 2 weeks. Yes.
Lord, serial number
My lord.
92, like my lord, 92. I appear for the petitioner, my lord. Respondent number 2 and 3, Advocate Mr. Loknath, appearing for BDI, called me
Which serial number, sir? Gautam?
92, my lord. The respondent advocate for BDI requested for a week's accommodation that is not
The
keeping well.
request
my
made by the Lana Council 92 or the request made by the Lana Council appearing for 2 weeks. Let us.
Oblige, my lord. Oblige, my lord.
My
My
lordship,
lord,
my lordship, serial number 89. Afternoon session ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ. ಮೈಸೂರಿನ senior counsel ಬರ್ತಾ ಇದಾರೆ.
80?
89. Afternoon session ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ. 89.
Highly oblige.
89.
my lord, 42, my lord, in this case.
Yes, sir.
I prayed for an adjournment, my lord, and you were also granted interim order has to be extended in that, my lord.
Which serial number?
42, my lord, admission.
42 interim order granted earlier.
42, my lord. I'm sorry, 42,
Yes.
my lord.
42, yes. Kodi. Monday? Yes. For being spoken to bidder, you have to file an IA. It's already signed. It is not signed for being, otherwise, file an IA for correction. 152.
Serial number 1 for orders, the verdict casing.
2 weeks time is granted. Yes. You take 2 weeks, 1 week's time is granted to take steps, and in addition to that, counsel appearing for petition is also permitted to send copy to the and a counsel representing the respondent number.
Serial number 1 to 5.
No, only one is 1 to 5. Okay. Yes. Interim order granted earlier, extended till next of year. Yes, sir. Correct.
Serial number 6.
2 weeks time is 2 weeks time is granted to take steps. You take steps. Sir, you take hand summons. Counsel appealing for the petition is also permitted to take hand summons insofar as the respondent is concerned. Next,
Serial number 7.
you get it.
The Navita.
2 weeks time is granted to take steps insofar as respondent is concerned.
Serial number 8.
1 week, 2 weeks time is granted to.
I am, my lord, I am serial number 8, my lord. In this
Ah.
case, my lord, I have completed the office objections, my lord, on 27/5/2022.
And a counsel appeal, yes. And a counsel appealing for
Again,
the submitted that again that they have raised.
Again, they have raised the other position, my lord.
And now you have to comply with it.
I'll comply, my
weeks time is
lord.
granted.
Second objection is concerned, my lord. Second objection is concerned. That is the order passed by the trial court, my lord. In the order, my lord, order 11 is mentioned. Order 7
Just a minute.
should have been mentioned. Page number 12, my lord. Page number 12. Annexure
Yes,
A. Annexure A. Annexure
Yes.
A, my lord. Irolage, the plaintiff has filed this application under order 11. This is order 7 rule 11 agbettagittu, but trial court judge has made a mistake, my lord. That can be overruled, my lord. In the inside, everything is right, my lord.
Okay. See, office objection raised regard to the provisions contained in the order dated
Annexure
7/2018 is overruled. The Lanang Council application is permitted to comply with the office objections, if any, within 1 week from today. Yes.
2 weeks, kindly grant 2 weeks.
2 weeks. 2 weeks. Very.
Much obliged, my lord. Much obliged.
To file it. The council appearing for the petitioners filed a memo dated so and so that the copy of the revision petition has been served on the Lana council representing the respondent. What is his name? Registry is directed to print the name of Sri K. Srinivas in the card list. Is this matter next week? This matter next week. Yes.
Serial number 10.
2 weeks time. 2 weeks time is granted to comply with
2
your.
weeks time,
Yes.
please.
Serial number 11.
2 weeks time is granted to take steps. Yes. You take correct address. Then next step, order 5 rule 20. 2 weeks time is granted to comply with the officer.
Serial number 12.
Yes, non-compliance of officer. Paper? Paper. Yes, sir. On a counsel appealing for the petition submitted that the petition herein is not seeking any relief against the defendant number 4, 7, 10, 15, 16, 19, 20 and 23 in OS number 26510/2021. Accepting the submission made by the Lana counsel appealing for the petitioner at the risk of the petitioner. Office objection is overruled. Yes.
Next objection is plaint present ಮಾಡಿದಾಗ ಕೋರ್ಟ್ ಫೀ ಎಲ್ಲ ಬರ್ದಿರ್ತಾರೆ ಅದನ್ನ ಲೈನಿಂಗ್ ಹಾಕಿಲ್ಲ ಲೈನ್
Office objection with regard to seal number 1 is also overruled. Yes. Is this matter for admission next week? Not today. Tuesday la CRP la CRP ತಗೋಬೋದಲ್ಲ ಜಾಸ್ತಿ ಇದೆ continue.
There is no relationship of landlord and tenant. We have to have
18th. Two weeks time is granted to take steps in so far as 2 weeks time is granted to take steps. 2 weeks time is better time. Huh? Time is granted to take steps. Oh. 2 weeks, 1 week's time is granted to take steps insofar as point number 2. Is this matter for admission on date? Sir, copy is in your house.
Napoli Lordships.
Is it 2 weeks time?
I request your Lordship to kindly see the order dated 29/7/22.
You have to take a furnisher, take notice.
But your Lordships have already noted that I filed a memo to dispense with notice to respondents 2 to 12. And on the last occasion, Lords, an order is made, but only
Order is already passed.
12 is missed out, Lords. That's all. 29/7/2022.
By order dated 29/7/2022, notice to respond number 12. By order dated 29/7/2022, notice to in terms of the memo dated 5/7/2022, notice to respond number 2 to 12 is dispensed with. That at the risk of the petitioner hearing. That way of the matter, taking steps does not arise at all. Yes.
I request for next Friday, it could be admission.
Release this matter next week.
Next Friday, Lords.
Let us release.
Because the reason is before the trial.
Yes, sir. Yes. Next week.
I appeal for the petitioner in this case, my lords. My lords, short points involved are point number 2, office objection, my lords. They are telling that I have not stated the pending proceedings. No proceedings are pending before the court because it was a miscellaneous petition
File. The entire sheet is meant for you in the card list.
My lords,
file a memo one by one.
My lords, and the the third office objection.
You file a memo to that effect because entire sheet is for complaints. You file a memo one by one.
I will file a memo, my lords.
Yes. 2 weeks time is granted to comply with the office objection. Yes. What is the discrepancy in the name of defendant number 35? 2 weeks. 2 weeks time is granted to comply with the office. No, let us see. Good evening. Revision is maintained. No representation on behalf of the petitioner. List of declarants. compliance. Seventh time. 1 week's time is finally granted to comply with the office objection since the complaints has not been made for 7 times. Accordingly, 1 week's time is granted to comply with the office objection, feeling with the appeal shall be dismissed without reference to bench. Await. Yes. Whether it's admitted, we take it up for next 2 weeks around admission. This matter for admission on 2 weeks put on. Yes. Rectification of office objection raised on IA-12 amendment. What? 2 weeks. What's the amendment you thought? What is subsequent development? Correct. Where is that? Where is the amendment? What is the amendment? You go to your application. So is the amendment runs more than repetition. Amendment pages runs more than the repetition pages. You're tempted to delete so and so, add, withdraw and file. Huh? Now you cannot. Need not. That could be taken up. That could not. No, this cannot be deleted. So 2014 now you cannot take the advantage of this situation. Very well. Or the Lana Council appealing for the petitioner and Lana Council representing the respondent on IA 1 of 2022 list. Undisputably, this petition is filed in the year 2014. An amendment sought in IA number 1 of 2022 after lapse of 8 years, taking into changing the nature of the relief sought for in the petition itself. That view of the matter, the relief sought for in the application in IA number 1 of 22 cannot be considered. Accordingly, IA number 1 of 22 is dismissed. Yes. Repetition will be there. Repetition is there. Only application that I have discussed. What do you want to impede now? Yes, sir. It is analogous to the 2014. Correct. So in the dismissal of the IA 1 of 2022, IA 2 of 22, filed by the petition herein to propose to implead, the proposed petition number 2 does not arise at all, since the proposed petition number 2 is the vendor of the petitioner. Accordingly, IA 2 of 22 is also dismissed. Yes. Rectification of office objection. 2 weeks time is granted to. Whose name has to be? Or? Now you are appealing. Whose name has to be deleted? Full stop. Shivcharan, Lana Council appearing for the petitioner submitted that he has entered appearance. And in that way of the matter, registry is directed to delete the name of Lana Council Shri Vishwanath Shetty V and Gohar Unisa representing the petitioner. Yes. Yes. Yes, sir. Already not comply with this. Sorry, in terms of the order dated at 22/7/2022, writ petition is dismissed. Yes. Dismissed. Same order. Writ petition. Order sheet. Order 7/2022, writ petition is dismissed as the office objections are not being completed. Yes.
CRP would not be maintainable.
CRP is not maintained. Yes, sir. Sitaram.
In this case, second
The
respondent,
objection rises, the revision is not maintainable.
both were heard and matter has been admitted. If the IA is considered, then CRP merits only, it has to be considered. Matter has to be heard
The
on
primary
merit.
objection is the revision CRP is not maintainable.
ಅದಾಗಿದೆ ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿ ಮತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದು ಸಾಹೇಬ್ರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿ ಅಡ್ಮಿಟ್ ಮಾಡಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Whether it is overruled, that how the revision is maintainable as to.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ, ಅಲ್ಟಿಮೇಟ್ ರಿಲೀಫ್ ಇಸ್ ಗ್ರಾಂಟೆಡ್ ದೆನ್ IA. Nothing remains to be decided in the suit. Kindly see the prayers in the.
Just 1 minute. Just one. I think if you look at the order dated 8/7/2022,
Yes,
in fact, by way of answer, she so-and-so, Anup Sitaram Rao for petition submits that arguments will be addressed on the maintainability of the revision also.
ಏನಾಗತ್ತೆ, ಅದು ಬೇರೆ ಇದು ಬೇರೆ ಆಗೋದೇ ಇಲ್ಲ. My lords will have to decide. If my CRP is not maintainable, then I will have to be permitted to prosecute my writ.
Yes.
According to me,
writ is maintainable. Actually, writ is maintainable.
No, I will be convincing your lordships that the writ cannot be filed because the ultimate relief which the plaintiff expected in the prayer is granted in the IA.
Yes.
And
no, this thing you can urge in the writ petition.
ಆಗಲ್ಲ, ಇದು CRP is maintainable. I will convince my lord and argue the merit on merits also.
No, on merit, not on merits. Just you say how the revision is maintainable.
Revision maintainable ಅಂದ್ರೆ ನಾವು plaint ಓದಬೇಕಾಗುತ್ತೆ prayer.
Yes.
We have the amended 115 of CPC.
Correct. No. Again,
ultimate relief is granted.
This impugned order is passed under Order 12 Rule 6. Necessary forms of application for registration of the lease deed. Now, only remedy is
that is his prayer. The lease is granted for 60 years.
Yes, sir. That you have to that you have to question in WP, not in revision. There is a bar in the proviso.
Both proceedings are same to me.
No, not same. Revision is different. WP is different.
ಅದಕ್ಕೆ
you file the WP better.
ಇಲ್ಲ ಒಂದು ನಿಮಿಷ. My lord will kindly give me time. I will get the second respondent also served.
Need not be. His presence not required. Just you have to say the maintainability of the revision.
I will argue on that.
My lords argue now.
If ಇವತ್ತು ಇನ್ನ ಸೈಟೇಷನ್ಸ್ ಕೊಟ್ಟು ನಾನು ಫಿಸಿಕಲಿ
ಸೈಟೇಷನ್ ಏನು ಬೇಡ ಅಂತ ನನ್ನ ಪ್ರಕಾರ.
ನನಗೆ
impugned order is passed on Order 12 Rule 6.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅಲ್ಲ ಕೊಟ್ಟಿರೋದು, ಅಲ್ಟಿಮೇಟ್ Now kindly see the prayer granted
Sir,
and prayer
sir,
made in the plaint.
Yes, sir, not like that. The order is passed under order 12 rule 6.
Nale CRP alone had to be filed antadre kashta agbidutte because it is a contentious matter.
Illa. See, so order 12 rule 6 revision under 15 baralla 227 is in fact maintainable.
This was examined not only by me, by another advocate in Chennai, and he has sent certain citations also to
Yes,
convince my lords by producing them. I will file all of them and argument.
Interim order illa alla.
Ide.
Then that has to be now looked into. Now argue the matter now. See, revision is not maintainable. It is prima facie we can make it.
Citations kottu nanu.
Citations kottu.
I will have to convince my lord that.
Yes, let's next week let us will tell him in this petition, and a counsel representing the respondent, invited the attention of the court to the order dated 8/7/2022 and argued that the revision, the present revision petition is not maintainable under section 115 of the CPs. In this regard, Lana counsel appearing for the petitioner seeks short accommodation to produce certain citations, certain authorities of the various high courts and the Honorable Supreme Court. In this regard, opportunity is given to the petitioner to argue the matter next week on the 25th.
September 1st week.
No, 25th of yes, 25th. Yes. It is also made clear that the Lana counsel appearing for the petition submitted that he will submit on the maintainability on the next step. Yes. Yes, sir.
Obliged.
Which is that, sir? Next. Propose legal heirs of the deceased R1. Issue emergent notice on IA 1 of 21. Yes, sir. Pleading proposed applicants R2 and R. Who are they? Who are the impleading applicants? Agreement. How can your agreement will on what basis the agreement? What is the prayer in this one? But of course, is a request made by the counsel appearing for the respondent 2 and 3 just after 2 weeks. Yes.
Number 28. Sharat Kumar.
Delay of 160. Delay could be yes. 164 days. 2 years is it putting. One minute. File objections. Just let us fill. Which is the impugned order, sir? Just a minute. Order 7 rule 10 was rejected. Return of plaint. When was the order passed? 5/2/2020. Correct. 25/3. 25. Where you stated in your IA, where you stated? Where is that you have stated? You have filed and withdrawn. Paraton, I submit that we had filed a writ petition in 21. When did you file a writ petition? 16/3/20. ಅದಕ್ಕೆ 2020 ಹಾಕಿದ್ರೆ 21 ಅಂತ WP ಬರಲ್ವಲ್ಲ? ಅಲ್ಲಲ್ಲ 2020 ಅಲ್ಲ ಅದು. We filed 16/3/2020. It should be WP of 2020, not 21. Alva? Huh? It should be in 21 only. Allah, it's not question. You leave apart them. According to you, you have filed writ petition in 16/3/2020. Then it should be a writ petition of so and so of 2020, not 21. When did you file the writ petition? When did you file the writ petition? Yes, sir. 16/3/20. But go to paragraph. You take read para 10 of your affidavits. Which is that writ petition? 20? Sir, 20 ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ writ petition 21 ಹೇಗೆ ಡೇಟ್ ಬರ್ತದೆ? No. Correct me. Sir, when did you file the writ petition? 16/3? Yes, sir. Then the number was WP number 7138. You file a better affidavit. Let me will file a better affidavit. You file better affidavit. And a counsel appearing for the petitioner, seeks 2 weeks time to file better affidavit with regard to explaining the delay in filing the revision petition against the impugned order. Yes. No. You file it. You file nothing. You file a better affidavit. You file affidavit. 68 days. Issue notice on IA 1 of 22. Notice of condone rule. Notice ಆದ್ಮೇಲೆ ತಾನೆ ಕಂಡೋನ್ ಮಾಡೋದು. Issue notice on IA 1 of 22. Issue 1 of emergent notice on IA 1 of. What do you mean? 29/3/2019. Why it was dismissed? Not? Okay. So it is your affidavit. Sorry. Except in the cause shown in the affidavit accompanying the application in IA 1 of 2020 and IA 2 of 20. Order dated 29/3/2019 is set aside and the appeal is restored on file. And as such, IA 1 of 2020 and IA of 2020 are allowed. Yes, sir. Let us see. It's an early level. Let it be restored thereafter. 1 of 22 is not pressed on them. Not pressed. Yes. 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 More than 3 years, sir. You are seeking compensation. One minute. May be allowed with cause. Except in the cause shown in the affidavit accompanying the application in IA 1 of 2021, delay of 1021 days in filing the appeal is condoned, subject to the appellant hearing deposit rupees 5,000 rupees to the Advocates Association Library, Bangalore. Yes, within 4 weeks.
Serial number 32,
Issue notice has to issue. Notice has to go. Huh? No, IA 2 of 22 has to go. Maybe allowed. Madam. So the council appearing for the respondent number 2 submitted that the respondent number 2 has no objection to allow IA number 2 of 2022 to allow the application in IA number 2 of 22 for impleading the whom do you want it? Impleading the whom do you want? Just one. Statement of impleading. 6-17. Yarn. Impleading the chief executive officer and executive member, KIADB, Kanija Bhavana Race Course Road, Bangalore 7. The said proposed impleading respondent B array as the respondent number 3, and a council appearing for the petition is permitted to amend the cost rate. Yes, ma'am. Yes, in the meanwhile, and a council appearing for the petition is permitted to file the amended cost rate.
serial number 33, 60.
Malad, I appear for the respondent number 3 and respondent number 4 in the
Where's filed who has filed a vacating statement? Huh? Respondent number 2. Who represent after 3? Okay. Permission filed by the advocate petitioner. Are you here? 33.1 ali. And a council appearing for the petitioner submitted that IA 1021 is allowed on 6/7/2022. In that way of the matter, no further orders are required on IA 102021. Then a council appearing for the petition is promoted to take steps insofar as the proposed petition. Notice. It is also submitted that Shri Jagadish HT is appearing for the proposed petitioner on IA 2 of 2021. In that way of the matter, no further requirement is made insofar as taking steps by the petition hearing. Yes, sir. Which one? Yes. In that way of the matter, IA 2 of 21 is allowed. Interim order granted earlier extended until further orders. Yes. Which respondent? Which yaar? Which way? No, there are 2 petitions. In which petition? Yes, ma'am. Who are they? No. Whether what you dismiss agide? Padi man. Order sheet. WP 2659. No issue notice anta agide. no representation on the change it. Yes. No issue notice on IA 2 of 21. Ah. 2 of 21. Let us will see later.
Number 34, developer claim.
Yes, sir. A request made by the council applying for the petition is stopped at 2 weeks. Interim order granted earlier, extended till next stop hearing. What about next matter? Have you paid cost? Yes, madam, paid. And a council applying for the respondent number 2 and 3 submitted that the cost of rupees 1,000 is paid. My registry is directed to verify this. Yes. It is there. Yes. It has to be added. Furnished number. Furnished. Then a council applying for plus tag along with WP number so and so. Yes. Then a council applying for the petitioner submitted that the petitioner's file memo dated 8/8/2022. Registry is directed to put up the said memo by next date of hearing. Yes, sir.
Madam, serial number 35. Madam Soumya.
Yes, sir.
Actually, the respondent had filed a
Yes, sir. It may be used. In this petition, the petitioner sought for transfer of MC number 22 of 2019 before the pending consideration before. Please sit down. Please sit down. Sit down. Pending consideration before the senior civil judge and JMFC at Aliala to competent family court at Bangalore. Full stop. Third, the Lana Council appealing for the parties, taking into consideration the grounds urged in the petition and in your the fact that the petition hearing is residing at Bangalore with her aged mother as well as having a minor daughter, and in that way of the matter, taking into consideration the law declared by the apex court in a category of decision that the convenience of the wife and the children has to be looked into while considering the application under section 24 of CPC, petition is allowed, and MC number 22 of 2019 pending consideration before the senior civil judge and JMFC Aliala is withdrawn and made over to the competent court at the family court Bangalore. And see Miss that will stop. It is also submitted by the Lana Council appealing for the parties that the petition hearing has filed CMIS number 603 of 2019 before the 603 of 2019 seeking maintenance under section 125 of CRPC, and MC number 4678 of 2019 seeking restitution of conjugal rights, and same is pending consideration before the which court? Second additional family court at Bangalore, and in that way of the matter, it is ordered that the MC number 22 of 2019 pending consideration before the senior civil judge and JMF Aliala be transferred to the second additional family court at Bangalore. Yes. Yes, sir. 24 I cannot do that. 24 I cannot do that. Yes. Yes, sir. Yes, sir. Correct. Yes, sir. Let the same this petition should also go. Yeah. Irrespective of the same. That you leave. Marriage, children born, that's all not considered. Anyway, she has filed the matter is pending consideration before, and an application is also filed in maintenance is before the family court to Mysore.
And also we got to
No. Continue. That's why this should also go to Mysore. Nothing will happen to the husband in Mysore. Then it is. Then take appropriate procedure under CRPC. That's all. This heard the Lana Council looking for the parties. In this petition, the petition has stated that the petition has filed complaint under section 12 clause 1 clause 2 of the Protection of Women from Domestic Violence Act 2005 before the first additional CJ and JMFC Mysore, and also filed an application under section 125 of CRPC seeking maintenance, and same is pending before the fourth additional judge family court at Mysore. Full stop. In that way of the matter, taking into consideration the hardship that may be caused to the petitioner herein, as she has stated at paragraph 23 of the petition that she has no source of income to travel regularly, and also in a catam decisions, and also taking into consideration the law declared by the apex court in the case of Sumita Singh versus Kumar Sanjay and another, reported in 2001-10 SEC 41. I am of the view that the MC number 1642 of 2020 pending on the file of the fourth additional principal judge family court at Bangalore be withdrawn and made over to the fourth additional principal family judge at Mysore for convenience of the parties to for the convenience of the parties as such. Accordingly, petition is allowed. No. I know. I don't know how many cases are. That cannot be done. Yes, sir. Very good. I think there are two petitions. Just which is that petition actually? Next one, please. 80 of 21. 80 of 21. 209 of 20. In CP number 80 of 2020, the petitioner has sought for transferring the GNWC number 16 of 2020 pending consideration before the principal judge family court at Shivamogga to the senior civil judge at Kundapura. In CP number 20 in 80. In CP number 209 of 2020. The petitioner has sought for transfer of MC number 201 of 2020 pending consideration before the family court Shumagga to the Dana Senior Civil Judge Court at Kundapura for disposal in accordance with the stop. Taking a full stop, having heard the Lana Council appealing for the parties and taking into consideration the fact that the petitioner is a resident of Kundapura and having a child aged about 1 year old, and therefore, it is convenient for the petitioner's hearing that the petitioner be convenient in the interest of the petitioner's hearing, as the same is convenient for them to appear before the competent courts at Kundapura, and as such, the petition in GNWC number 16 of 2020 pending consideration before the Principal Judge Family Court at Shivamogga and MC number 201 of 2020 pending consideration before the Family Court at Shivamogga are withdrawn and transferred to the Senior Civil Judge Court at Civil Judge to the court of the Senior Civil Judge at Kundapura, for disposal of the same. The it's also made clear that the said petition has been the transfer of these two petitions are made in the interest of the petitioners, as the petitioners is having a child aged about 1 year, and the Shivamogga is far away from the Kundapura to attend the proceedings by the petitions. Yes. First we take 141. Yes, sir. Yes, sir. I will take it up. 41. CP 4521. In MC number 4767 of 2020. She is a resident of Bengaluru. Yes, sir. Yes. COVID should unite, not separate. COVID should make for uniting people, not separate. Okay. Okay. Yes. Yes. Just a minute. Whether he's working in Bangalore or no, that's all. Work from home, but work from home it will be there for short period. Discretionary and the convenience of the parties.
Complaints have been filed by right, and there is lot of harassment and messages are also there. But I know I'm not 24
So that's the outcome of these MCs. Yeah, there will be there. They're all common. Something else. It may be transferred to Bangalore. Slowly. MC number 45, yes, 45 of 2020. Please sit down. Please sit down. MC number 45 of 2021 is filed by the petitioner seeking transfer of MC number 75 of 2020 pending consideration before the Principal Judge Family Court at Chikkamangaluru to the competent Family Court at Bangalore. CP number 141 of 2021 is filed by the respondent husband seeking transfer of MC number 4767 of 2020 pending consideration before the 6th Additional Principal Judge Family Court Bangalore to the Principal Family Court at Chikkamangaluru. Stop. Ardilana Council appearing for the parties. Stop. Madam so-and-so, Madam Kalpana Lana Council appearing for the petitioner wife, contended that the respondent husband was earlier working at Bangalore and now he has shifted to Chikkamangaluru where he is working. However, the head office of concerned employer is situated at Bangalore, and at any point of time, the respondent husband may come back to Bangalore for continuance of his occupation. In that regard, she submitted that it is difficult for the petitioner wife to travel from Bangalore to Chikkamangaluru to attend the proceedings on every regular intervals. For contrast, Sri G.S. Balagangadhar Lana Council appearing for the respondent husband, counter the submission made by the Lana Council appearing for the petitioner and contended that, since the respondent husband is settled at Chikkamangaluru and it would be difficult for him to travel all the way from the Chikmagaluru to Bangalore to attend the proceedings. And also there are certain complaints are also filed before the jurisdictional police station with regard to threatening calls which had been made by the petitioner's wife and her family members. And accordingly, he submitted that the petition filed by the petitioner wife be dismissed by allowing the petition filed by the respondent husband in CP number 141 of 2021. As to having heard the Lana Council appearing for the parties, it is not in dispute that the MC number 4767 of 2020 is filed by the petitioner seeking restitution of conjugal rights and same is pending consideration before the 6th Additional Family Court at Bangalore. So that apart, MC number 75 of 2020 is filed by the respondent husband seeking dissolution of the marriage and same is pending consideration before the Principal Family Court Chikkamangaluru. So, taking into account the grounds heard in the petition in CP number 45 of 2021, and also the law declared by the apex court in the case of so and so 2001-10 SCC 41, whereby the apex court has held that the convenience of the wife and the children have to be looked into while considering the application under section 24 of CPC, which is a discretionary in nature. And in that way of the matter, since the respondent husband was earlier working at Bangalore, it may not be difficult for him to attend the proceedings at Bangalore as he is familiar with the place. And in that way of the matter, I'm of the view that the CP number 141 of 2021 filed by the respondent husband is dismissed, and CP number 45 of 2021 filed by the petitioner wife is allowed, and as such, the MC number 75 of 2020 pending consideration before the family court at Chikmagaluru is withdrawn and made over to the competent family court at Bangalore. Yes. Yes. No, nothing. It's only 24. Only 24. That's it. Yes, sir. No, what is the matter? Matter is settled. 3313. It is settled.
Mediation, directing both the parties to present on
20th. That a counsel appearing for the party submitted that there is a likelihood of the settlement in the matter and accordingly sought for transferring this petition to the mediation center at Bengaluru. That way of the matter, parties are directed to appear before the mediation center on 20th date so and so at 2:30. 2:30. MC I cannot. Where?
This petition.
It is also submitted that as this civil petition is filed arising out of MC number 3313 of 2021, pending consideration before the 6th additional judge, Family Court, Bangalore, and same be made over to the mediation center for early settlement. Please be informed. Yes.
I may be permitted to appear through VC.
Yes.
Yes. Wife's petition sought for transfer of petition.
What is awaiting mediation center?
But so this matter was referred to mediation center at Chitradurga. There, my lords, so they are dodging the proceedings. They are not appearing. If at all, if they want to settle, my lords, let them settle in the MC proceedings itself.
MC petition.
Yes.
Yes. This petition is filed by the petition under section 24 of CPC and seeking transfer of MC number 134 of 2021 pending consideration before the principal senior civil judge and the CJM at Mandya to the competent family court at Chitradurga. I heard the Lana Council appearing for the parties. It is submitted that the petition hearing is having no support and it is difficult for her to travel from Chitradurga to Mandya.
I'm sorry.
The Mandya to attend the proceedings. And further, it is stated that she has to depend upon the earnings of her parents to attend the proceedings at Mandya by traveling for more than 300 kilometers. And in that way of the matter, taking into consideration the Catalan decisions by the Honorable Supreme Court, wherein it is held that the convenience of the wife should be looked into, and as such, the MC number 134 of 2021 pending consideration before the principal senior civil judge and CJM at Mandya is withdrawn and made over to the competent court of principal senior civil judge and CJM at Chitradurga for final disposal. Yes, accordingly petition allowed.
Great.
Yes. Which petition? Tumkur? This petition is filed by the No. Let us will see. This petition is filed by the petitioner under section 24 of CPC seeking transfer of MC number 215 of 2021 pending consideration before the principal judge, Family Court at Tumkur, and to transfer the same to the competent court of principal senior civil judge and matrimonial senior judge at Bhadravati. Heard the Lana Council appearing for the parties. It is submitted that the petitioner submitted that the petition is It is inconvenient for the petitioner to travel from Bhadravati to Tumkur to attend the proceedings in MC number 215 of 2021, as she has to accompany someone as she is having a daughter who is minor and aged about 2 years. And in that way of the matter, taking into consideration the factual aspects of the case, that it may be inconvenience for the petitioner here to attend the proceedings at Tumkur. And in that way of the matter, MC number 215 of 2021 pending consideration before the Principal Judge Family Court Tumkur is transferred and is withdrawn and transferred to the competent court of Principal Senior Civil Judge at Bhadravati. Yes.
Number 42, number 43.
So 43, my lord's wife's petition.
Yes.
Not for transfer of petition from my lord's Mysore to my lord's Puttur.
Mysore to
Puttur. And my lords, already in Puttur, my lords, there is one domestic violence petition filed by me is pending.
That is CMS number 14 of 20.
Oh, yes.
This petition is filed by the petitioner seeking transfer of MC number 674 of 2021 pending consideration before the 4th Additional Principal Family Court at Mysuru to the Court of Senior Civil Judge at Puttur, DK District. It is heard the Lana Council appearing for the parties. It is submitted by the Lana Council, Sri Rajshekar Lana Council appearing for the petitioner that the petition herein has filed a CMS number 14 of 2021 before the Principal Civil Judge and JMFC at Puttur, and therefore the respondent herein in counterblast has filed MC number 674 of 2021 before the Family Court at Mysore. He further contended that the petitioner herein find insecure to attend the proceedings at Mysore and accordingly sought for transfer of proceedings. Having taken note of the submission made by the Lana Council appearing for the parties and taking into account the grounds urged in the petition, as the distance between the Puttur and Mysore, Allah?
Yes, please.
But stated Bangalore.
Mysore.
Page 5, last line. Cut and paste.
Yeah. Sorry.
Puttur to Mysore is nearly 225 kilometers. It would be difficult for the petition wife to attend the proceedings. And in that way of the matter, as already the CMS number 14 of 2021 is pending consideration before the competent court at Puttur. I have to view that MC number 674 of 2021 pending consideration before the 4th Additional Principal Family Court at Mysore is be withdrawn and made over to the competent court of Senior Civil Judge at Puttur, DK for final disposal. Accordingly, petition is allowed.
Grateful.
Respond.
Officer Madilla anta last time helidru acknowledgement kottidini.
Lana Council appealing for the petitions also submitted that he has served copy of the petition to the Lana Council representing the respondent. Yes.
Please.
Yes. 40? Yes. Serial number 94. 45. 44. Yes. Bangalore. Good answer. Heard the Lana Council appearing for the parties. The short question involved in this petition filed under section 24 of CPC is with regard to transfer of MC number 4092 of 2020 pending consideration for the 2nd Additional Principal Judge Family Court at Bangalore to the competent court of Principal Civil Judge within bracket Senior Division close the bracket at Bhadravati. Heard the Lana Council appearing for the parties. It is stated in the petition that the respondent herein has filed MC number 4092 of 2020 seeking dissolution of the marriage, and same is pending consideration before the family court at Bengaluru. At paragraph 7 of the petition, the petitioners narrated the difficulty in attending the proceedings and taking into consideration the averments made in the petition. I am of the view that, in order to make convenient for the wife to attend the proceedings without any hindrance, MC number 4092 of pending consideration before the second additional principal judge family court at Bangalore is withdrawn and transferred to the principal civil judge within bracket senior division of Bhadravati 43. Yes, sir. Yes, sir. Bangalore. Only one change. No. B has to be changed by M. She is in Bangalore. Mangalore. Only change is.
Simply they are finding awesome different
Request them, don't fight. Request them, don't fight. Any other case.
That they have to be. Because whenever we go, there is a document also. We go on occasions, the police have gone. And when we are stayed in a hotel also police came and saying that you have to come for police station. That is the harassment. Same thing. The only submission that at least they have to put an end for them.
That cannot be taken into 24. This petition is filed under section 24 of the CPC, seeking transfer of MC number 653. Please sit down. Transfer of MC number 6537 of 2021, pending consideration before the 6th Additional Principal Judge Family Court Bangalore to the competent family court at Mangalore. Lana counsel appealing for this part. It is submitted that the petitioner herein is residing at Mangalore and having 2 minor children. Taking into consideration the interest of the petitioner as well as the children, and the law declared by the apex court in the case of so and so reported in 2001 10 SCC 41. I'm of the view that in the event if the petition is not allowed, the hardship would be caused to the petitioner as she has to take care of 2 minor children. In that way of the matter, I'm of the view that the petition deserves to be allowed by transferring the MC number 6537 of 2021, pending before the 6th Additional Principal Judge Family Court Bangalore to the competent family court at Mangalore. 24 ಅಲ್ಲಿ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes. Notice and stay as per.
Lords, yes. Appear for respondent, Lords. Lords, I have no objection for transfer of the petition.
You know no objection for transfer from Anekal to Bangalore. You can go to Anekal. It's not too far. Huh?
Lords, actually, it's a counterblast petition, my lords. RCR restitution has been filed here, but I don't have any problem, my lords. My lords, general direction.
Very good. This petition is filed by the petitioner seeking transfer of MC number 5. Yes.
Both the cases direction may be issued to the trial court. Both the cases can be clubbed together and tried together.
No, let us see. Section 24 of CPC, seeking transfer of MC number 5034 of 2019, pending before the 3rd Additional District and Second Judge Anekal to the 6th additional senior civil judge, Bangalore Rural Court at Bangalore. Just heard the Lana counsel appealing for the part. This submitted that the respondent hearing is also working at Bangalore, and the petition hearing has filed petition under section 9 of Hindu Marriage Act seeking restitution of conjugal rights in MC number 574 of 2021, and same is pending consideration before the competent court at Bangalore Rural, and therefore, taking into consideration the reasons assigned in the civil petition, I am of the view that the MC number 5034 of 2019 filed by the respondent at third additional district and session judge Anekal be withdrawn and transferred to the competent court, particularly the 6th additional senior civil judge, Bangalore Rural Court at Bangalore, for final disposal in the matter. Yes.
Perhaps 6 months time may be granted, my lords. She is dragging it.
No, that cannot be done. Yes. Issue notice. Issue notice. 49. 49. Issue, yes. Notice and stay. Yes. Notice and stay as prayed for. Yes, good. Yes. 20? Where is he now? Yes, in Chittoor. At the request made by the Lana Council appearing for the respondent. This next week, next week, date. Yes. Yes, sir.
Last week, even regarding the document which you were.
1 minute. Just 1 minute. Where she is working, sir?
This is the news for me now. Without any document,
Let us.
I'm verifying this. Already you said that I am working for a bank.
Where, madam? Just where, madam? Where she is working?
She is working at number 58, first line road station.
Which madam? Now today that you have filed. Which page that she is working? She is working at? Yes. Solutions India Private Limited. You file an affidavit that she is not working. If you file an affidavit she is not working, it will be accepted. So that's a very simple.
It's the moment that I am working there. This is only the.
I have stated.
No, nothing will happen. See, you say.
I am not aware.
See, according by way of affidavit, they are saying that you are working in Bangalore. You say by filing affidavit that you are not working. That's all. Yes, Lana Council.
And I have also put the account number where the thing is transferred to her. And that too it is in.
It is always good, madam. Transfer ಆಗ್ತಾ ಇರಲಿ ಬಿಡಿ. Always. If any credit is made to the account, always good. Then at the request made by the Lana Council appearing for the petition is next week. Date. That's when do you want? Yes, 25th. Yes. Notice and stay as prayed for. This is he will argue. Yes. Huh? What objection you will file? You tell me at least what objection you will. Third, the counsel applying for the parties. Huh? No, it will be allowed. It will be allowed, sir. Third, the counsel applying for the parties. In this petition, petitioner is seeking just really. Otherwise, I will reasons to follow. Just agbiಟ್ಟು ಜಾಸ್ತಿ ಇಲ್ಲ ರೀಸನ್ಸ್ ಫಾಲೋ ನೆಕ್ಸ್ಟ್ ಯಾರ ಬಂದ್ರೆ ಇನ್ನೆರಡು ಮಾಡೋಣ 15 ಆಗುತ್ತೆ. In this petition heard the counsel applying for the party. In this petition, the petitioner, please sit down. Petition is sought for transfer of MC number 1651 of 2020 pending consideration before the third additional principal judge, Family Court, Bangalore, to the competent court at Malur. Having taken note of the fact that the respondent herein has filed MC number 1651 of 2020 seeking dissolution of a marriage, and the petitioner herein is the resident of is residing at Malur town, and she has no, and it is stated by affidavit that she has no income for her own, and she is unemployed and depending on the earnings of her parents. And therefore, I am of the view that, taking into consideration the fact that the law declared by the Apex Court in the case of Vaishali Sridhar so and so, reported in 2016-14 SCC 356, MC, I'm of the view that the MC number 1651 of 2020 pending consideration before the third additional principal judge, Family Court, Bangalore, is withdrawn and transferred to the competent family court, to the family court irala, to the competent court at Malur for final disposal. In the result, petition is allowed. Yes. Yes. So in this petition, this petition is filed under section 24 of CPC seeking transfer of the MC number 29 of 2022 pending consideration before the senior civil judge and JMFC at Chennagiri to the family court at Davanagere, competent family court at Davanagere. Heard the counsel applying for the petitioner. Notice to respondent is held sufficient. Take a note of the fact that the petition herein is working as a staff nurse in Bapuji Child Health Institute and a Research Center at Davanagere. And in the event if and also where the petition herein has a large complaint before the jurisdictional police under section 498A of IPC read with section 3 and 4 of Dowry Prohibition Act before the at Davanagere. I am of the view that, in the event if this petition is not allowed, the comparative hardship would be caused to the petitioner herein. And in that view of the matter, I am of the view that the MC number 29 of 2022 pending consideration before the senior civil judge and GMC Chennagiri is withdrawn and transferred to the competent family court at Davanagere forthwith. Notice and stay as prayed for. Notice and stay as prayed for.
For the petitioner in this matter, my lord.
How the petition is maintainable?
Please, my lord, under section 23, it is maintainable, my lord.
You are agreed, then it has to go. How can This petition I have to have this court is having jurisdiction to transfer to the other state.
Please, my
Only
lord.
Honorable Supreme Court is having jurisdiction.
No, my lord. So I have stated one judgment, my lord, 1985 Karnataka
Oh, no,
1413.
not a judgment. Just you go to the language employed in 24, 25, 26 of CPC.
No, my lord. Kindly pass over the matter, my lord. I will get the judgment, my lord. Please. There is a urgency of stay, my lord.
Okay, okay. Pass over. Yes. Notice and stay as prayed for. Notice and stay as prayed for. Notice and stay. Up to 62. Up to 62 notice and stay as prayed for. Yes. Okay, Kotwal. Yes, Mr. Kotwal. Yes, Mubarak. No, one opportunity. One opportunity, let us give. One was the yes. No representation on behalf of the petitioner, and a counsel appealing for the respondent is present. Read it for urgency in the matter. In that way of the matter, in order to provide an opportunity to the petitioner hearing, list this matter next week date. Any day, convenient. Next week, just either following week. Following week. Yes. $66. No representation on behalf of the petitioner. Then a counsel appearing for the respondent is present. List after 4 weeks. Yes. Yes, sir. Just a minute. Just suit for partition.
The has been drawn, it has been acted upon. The later part of 5 years, we don't filed a suit.
You filed a suit.
The idea is that the authorized decree is not binding. It's by equal party.
Correct.
But the judgment of the Honorable Supreme Court is directly. No pressing is entertainable.
Correct.
And the agreed party has to file an application for the compromise has been ended to reopen our modifications.
Yes.
That suit is absolutely barred under the Honorable.
Yes, sir. What is the relief sought for in the earlier petitions? That is OS number 911. 911 of 2013.
Page number 53.
The 911. So what has happened in that case? Compromise. So on 22/2014, compromise. Yes, sir. Yes, sir. 79. Yes.
But the relevant portion of the order sheet member referring the matter and accepting the compromise. Number 108.
Yes. Yes, sir. It is this. What is reported is statement. Yes, sir. Rather decree in terms of the compromise subject to registration. Yes, sir. Now the present petition is present OS is filed. Where is the OS?
Page number 34 is the claim.
30? Yes.
The claim.
30. 4 ಅಲ್ಲ? Yes. Anyway, the earlier suit is stated at paragraph 4. Defendants colluded with compromise loans. The 6th defendant has not included some of the other properties and by have illegally got obtained compromise. Yes, sir. According to them, certain properties have been left out on the earlier occasion.
Properties have been left out of the one property by filing a memo got deleted.
The rest matter is same, then it has to be looked into. It has to be looked in trial only.
Proposition R23 absolutely barred the use.
No.
In respect of two properties which were left, my lord, the suit is maintained. Properties which were left in the earlier.
That is only ultimately the court has to take decision.
No, my lord, not in the new suit. Not in the new suit, my lord, including the earlier property.
Yes. No, if any properties have been left out and it came to know about the same now at the time of filing of this suit. And also, moreover, he has stated in paragraph 4 regarding the earlier petition, earlier suit.
No, my lord, he has stated for a moment
So that cannot be looked into now. Just see. Good evening. CPC. So it's not similar set. New properties have been included.
Only two properties.
And
separate suit is maintainable.
And moreover, he is saying that suppressing the real facts. Yes.
He is fighting the matter is getting for the local government. But then he is a party to the proceeding. Where he accepted the fact and compromise. Where it has been acted upon.
Thereafter, he came to know that certain fraudulent tax have been.
He is a party member.
Party thereafter, that's why he's saying that there's a fraud.
No.
It is not a fraud, he could not have known the real facts.
23 rule creation.
Paradilla. Judgment code. Because his entire cause of action is different now.
No, my lord, there is a fraud, my lord. I do object, my lord, the number 17.
Yes. Yes. Para
17.
Para 7. Yes.
The position that emerges from the amended provision of order 23 and no appeal is maintainable against a consent decree having regard to the specific bar mandated in section 96(3) of CC. No appeal is maintainable against the order of the court requiring a compromise or appealing order to record compromise in view of division of class of rule 1 or 40. No independent suit can be filed for setting aside a compromise decree on the ground that the compromise was not lawful in view of the bar contained in suit DE.
Yes, sir.
A consent decree operates as an estoppel and is valid and binding unless it is specified by which.
No, setting aside the earlier compromise order dated once, saying that these certain properties have not been included. That is the ground.
Oh my lord, the compromise, earlier compromise decree cannot be subsequent by estoppel. Where the failure part in the suit the kindly.
Yes, I've seen that. He's saying that has not the the prayer in the suit has to be read along with the averments in the plaint. Not yes. Yes. Anyway, certain properties have been left out.
Two properties in the two properties
Then there will be a full pledge. So whatever the court will say in the matter in due course of that.
Therefore, the only remedy is available. Remedy available to a party to a consent decree. To avoid such consent decree is to approach the court, which recorded the compromise and made a decree in terms of it, and established that there was no compromise. In that event, The court which recorded the compromise will itself consider and decide the question as to whether there was a valid compromise or not. It is so because a consent decree.
Write this point in the arguments, not in order 711.
23 root 3 and by the
Barala, sir. Sir, Barala.
23 root 3.
Sir, anyway, thing is stated in paragraph 4 of the plaint, saying that certain properties have been left out and fraudulently.
Part of the properties who were left by that second to the seat in a property which were left. But the consent decree cannot be questioned in by independent.
Yes. 23. 3. Just one more. 23. Yeah. Yes. When. Yes, sir. Rule 3A. 1 minute. Sir. Limitation. Yes. Compromise.
Those suits shall lie to set aside a decree on the ground that the compromise on which the decree is based was not out. 2, 3, capital A.
1 minute. No suit shall lie to set aside a decree on the ground that compromise which decree is based was not lawful. Now he is saying that it's unlawful. Fraud.
If it is unlawful, my lord, suit will not claim, my lord, it has to go before the same court if the compromise decree was recorded by the similar principles, my lord, another judgment, my lord, the Honorable Supreme Court.
Yes, sir.
In 2014, value 50, 471.
Yes, sir.
Apart from that, my lord, he has told the property after the compromise.
Yes, sir.
Compromise, my lord, he accepted and he has told the part of the property. They have entered into compromise.
Paragraph 11. It's manifest from the plain reading. Yes.
There one party agrees and the other denies adjustment or satisfaction of any by law or as compromise in writing and signed by the party. The court before who such question is right, then decide this. Which is important is that in terms of explanation for the agreement or compromise shall not be deemed to be lawful. It is the meaning of the said rule, the same is void or voidable under the contract act. It follows that in every case, where the question arises whether or not there has been lawful agreement or compromise in writing and signed by the party. The question whether agreement or compromise is lawful has to be determined by the court concerned. What is lawful in terms depend upon whether the allegation suggests any infirmity in the compromise and decree that would make such a void and violable under the contract. More particularly, Article 23 Rule 3 clearly bars the to set aside a decree on the ground that the compromise of which the decree was not lawful.
Was not lawful. That means unlawful. ಎರಡು negative ಇದೆ ನೋಡಿ. ಎರಡು negative under positive. No suit shall lie to so and so based on lawful. If we,
Article 23 Rule 3 clearly bars us to set aside a decree on the ground that the compromise in which the decree is based was not lawful.
Yes.
This implies that no sooner a question relating to lawfulness of the agreement or compromise is raised before the court that the based on the compromise. It is that the court and that the court allows to get extraordinary determine the question. The court cannot direct the parties to file a separate.
Here, the case of the plaint is that compromise decree because certain properties have been not added. It was they have pleaded the fraud. Therefore, the second.
Two properties were left.
Then
in respect of two properties were independent to the properties which are already compromised.
No, this is a final argument, not in this.
Basically, Rule 3 itself is a vast matter to maintain in the text.
Sorry.
Here, the implication is that the imitation of data was not factor law. So then, if it is like this, my lord, all the degrees, my lord, there is no end at all, my lord, to the litigation. The document is, my lord, partition.
I know.
Mediation, my lord, they allow to enter into the agreement. After few years, my lord, saying that there is a wire, there is a fraud, my lord. There is a end to litigation, my lord. The local level, the local level can compromise with regulatory. Okay, my lord. My lord, the sanctity, compromise, there must be sanctity, my lord. That is the reason, my lord, 23.3 has been inserted, my lord, by amending the CPC.
Yes.
He is questioning, my lord, earlier suit is not binding on duller part. Where is the compromise?
Yes.
All the compromise suits like come before this and
Got it. Yes, you're right. You're right. Right. This revision petition is filed by the precedence. This revision petition is filed by the legal representatives of the defendant number 1 and defendant number 2 to 5, challenging the order dated 18th February 2020 in OS number 46 of 2019 on the file of the first edition senior civil judge at Kolar, dismissing the application in IA number 3 filed by the defendants filed by the defendant number 1. Yes, sir. Yes.
Can you come to? Para 8 to 12. Therefore, on claim reading negative. Therefore, on claim reading the part would be a no crucial lie to set aside a detail identical portion can be considered by this court in a form. It is observed that it has a report that root 3A of 123 bars is moved to set aside the degree on the ground that the compromise on which the degree was not. It is further observed and there that agreement of compromise which is
clearly void and voidable shall not be deemed to be lawful.
And bar and the root 3A shall be attracted if compromise on the basis of which the degree was passed was void or void.
According to him, it is void.
In this case,
yes, Andre, I will dictate.
In this case, furthermore, in this case,
I will follow the very same case for him.
In this case,
he's saying that, sir, there is a fraud. That's why they say that.
Further, my lord, in this case, this court had occasion to consider in detail
earlier case.
The earlier decision of this court has been dealt by this court.
Yes.
Now, my lord,
I shall consider it, sir. Yes. This the plaintiff has filed OS number 46 of 2019, seeking partition and possession in respect of the suit schedule properties, and the said suit is contested by the defendants by filing written statement. In the meanwhile, the defendant number 1 has filed application in IA number 3 and order 7 to 11 of CPC, seeking rejection of the plaint for want of cause of action, and also as the suit is barred by limitation. The trial court, after considering the plaintiff has filed objection to the said application. The trial court, after considering the material record by order dated 18th February 2020, rejected the application filed by the defendant number 1 and order 7 to 11 of CPC. So, feeling aggrieved by the same, the legal representatives of the deceased defendant number 1 and defendant number 2 to which defendant has filed? 2 to 5 have preferred this revision petition. I've heard Sri Basavaraju Lana counsel appearing for the petitioner, and Sri Ramakrishna Hegde Lana counsel appearing for the respondent number 1. Sri Basavaraju Lana counsel appearing for the petition. Please answer. Please. Submitted that the finding recorded by the trial court rejecting the application filed under Order 7 Rule 11 of CPC is incorrect, as the earlier suit in OS number 911 of 2013 was filed for similar relief, which came to be disposed of in a Loka Adalat. However, in that way of the matter, the second suit on the very same cause of action raised by the plaintiff cannot be considered in view of the language employed under Order 23A of CPC. So in this regard, we refer to the judgment of the Apex Court in the case of 2014, in the case of Dash, reported in 2014-15 SEC 471, and Mr. So-and-so in the case of so-and-so, reported in 2022, volume 5 SEC 736. For contrast, the counsel appearing for the respondent sought to justify the impugned order passed by the trial court and argued that the plaintiff has have taken the plea of fraud committed by the defendants therein at the time of the conclusion of the proceedings in OS number 911 of 2013, and accordingly sought for dismissal of the petition. In the light of the submission made by the Lana counsel appearing for the parties, I carefully examined the finding recorded by the trial court. It is not in dispute that the OS number 911 of 2013 was filed between the parties seeking partition and separate possession in respect of the suit scheduled properties. The said suit came to be disposed of by compromise petition, by compromise entered into between the parties, and the final decree has been drawn on 20th February 2014. However, in view of the arguments advanced by the Lana counsel appearing for the petition hearing, I have carefully examined the averments made in the plaint. At paragraph 4 of the plaint, the plaintiff has pleaded that the sixth defendant has filed a suit against the plaintiff and defendants in OS number 911 of 2013 before the first additional civil judge at Kolar, and the said petition was ended in compromise decree. It is averred in the plaint that the plaintiff was illiterate and ignorant, and the defendants herein have played a fraud against the plaintiff and have not allotted the equitable share in favor of the plaintiff. And accordingly, it is stated that certain properties have been left out in the earlier suit in OS number 911 of 2013. And accordingly, it is stated that the said compromise decree is illegally entered, compromise decree is void. Full stop. Taking into consideration the plaint averments at paragraph 4 of the plaint, and apply the same to the case on hand where the application is filed under Order 7 Rule 11 of CPC. It is a well-established principle in law that while considering the application under Order 7 Rule 11, it is the duty of the court to look into the plaint averments alone and should not be misguided by the averments made in the written statement. In this regard, Lana counsel appearing for the petition has referred to the aforementioned judgment. Recently, in the case of so-and-so, Sri Surya Developers Supra, in brackets Supra, the Apex Court at paragraph 12, at paragraph 8, at paragraph 12 reads as under listed. Following the law declared by the Apex Court in the aforementioned case, where the Apex Court has held that the Order 23 Rule 3A of CPC shall press into service if the compromise is if is a law present service if the agreement or a compromise is lawful in nature. However, in the instant petition, the plaintiff has raised as pleaded that certain properties have been left out in the earlier suit in OS number 911 of 2013, and the said compromise petition is inequitable, and in that view of the matter, following the law declared by the apex court in the aforementioned case, I am of the view that the finding recorded by the trial court is just and proper, and the plaint cannot be thrown out at the threshold by a threshold on the ground that the earliest filed on the very same on the very same relief sought for, and in that view of the matter, revision. Yes, very well. Yes. Yes, sir. If other side is there, I will take it up now. In a previous matter. Yes, take it up. Next week, then I have already known. It's already transferred into my mind, even in your absence of absence. Huh? Yes, 2 weeks, not next week. 2 weeks date. Every day we have nearly 80 matters. No date. 68. Admit. I think a bar. There's a bar under. Admit. Admit. It requires details. Yes, sir. Admit. Registry is directed to secure the records from the court below. That's a different. It's a preliminary. 1969 Supreme Court. Dulabai. Square is section 9. Statutory. Statute is. Anyway, it is admitted. Why do you preserve your energy for it? Let us use. It requires. It requires details. Let us use. You filed an application. Let us use. But only thing is it has to be deposited. Let us. It will be considered. It will be considered in the latest. Yes, along with the mail.
What happens is
in the event if you succeed, you will get mean profits. Why do you? But the jurisdictional aspect has been raised. No, it's a 21. No. It's latest case for me actually in the board. Earlier CRP Sumaride 2013, 14, 15. Issue notice. Yes.
Lord, I appear for the petitioner, my lord. I request
yes,
for a week's accommodation. I am not well, my lord.
You're not well.
Please, next week.
Yes, the council appearing for the petition submitted that is unwell. So therefore, list this matter 2 weeks frequently.
The interim order has to be extended.
Just 1, 2 weeks. Not next week. Following. 1st of September.
Interim order has to be extended.
Interim order granted earlier, extended till next.
Published.
Second Marboda? Yes, 2nd of September. Yes.
Interim order.
Interim order granted earlier, extended till next of year. Yes.
Much of it.
2 entries. One minute. Withdraw and made over to the other. Because the thing is, the trial court has arrived at a conclusion that different cause of action. Yes. EP and SC. Yes. Yes.
As a consequence, these people are some pockets of that.
Yes.
Therefore, I try to look for permission.
Correct.
Permission to amend the matter.
In RFA proceedings. In RFA proceedings. In one. In RFA proceedings. Yes.
These people are when they people defense that will
Yes.
Now they will have the right to contest that also. I just want all this to be transferred to one quota. And I don't say this quota or that quota. Whatever quota.
So one in OS number filed in 2001, another in 2011 on different cause of action.
Cause of action is different, but it is the same property, and I claim.
And moreover, the evidence will be different.
But evidence is different. So far as the will, I should prove will in all the cases.
But different.
I don't want to be clubbed to my lord. They can be transferred to one court hall where the evidence can be full of them.
Yes. See what is saying, don't club it. Let these cases will be made over to the same court. Cause of action different. These different suits will be made over to the only one court. So in the event if go to the very same judge, learned judge, then there will not be any conflicting judgments.
In this case, there is a conflicting judgment. When we see all the things that is right, I am getting for
So now what he is saying may not be clubbed, but it may be made over to the common one court. So that could be done. It cannot be clubbed. I do agree. Leonard district judge was right in saying that different cause of action and the different reliefs have been sought in the suit, but it may be made over to the one court for convenience. And even the parties cannot miss the court hall, same court hall that it is easy for them. Let us be transferred to the one court. It cannot be clubbed, but go to the particular court. Yes, sir. Cause of action different. It may not be clubbed, different, but it will be made over to the only.
All the other suits because all of for all the suits for the judgment degree. Because set aside
No, what is you got what Leonard consists. He's not seeking for this code. He is sought for the clubbing of the petitions. One quota. That's all he is seeking.
What will happen? That will be clubbed together.
No, let there be a different judgments, but let it be rendered by the common judge so that he will be convergent with the factual aspects. Just a minute. See, OS number 4900 of 2011 is pending consideration before CCH-26, and the relief sought for is eviction delivery of possession. Just a minute. Another suit is 1321 of 2001. It's declared. Yes. Yes. But 5270 of 2011 it's a pending consideration before the CCH-62. Only 26 have to be read as 62. Reverse model this time. Sir, irrespective of the same. No, he's not seeking clubbing. We'll go to the same judge.
Yes, sought for all other persons. What he has sought, all other persons, he has sought for any application. And he has made the market for the request. In that circular, they could have filed between application. At that point of time, I will have the result.
So the scope is only section 20 of CPC.
So the scope itself is not maintainable. Not that is maintainable.
So that is main. That's all the merits. Here is section 24 seeking all this post 900, which is pending in 26 has to go to 62. Only reverse of number quotas number. 26 become 62. That's all. Could be done. Only sir. 15272 of 2011. CCH 6. Maybe the cause of action is different. It will go to the very same judge. Learned judge. So cause of action one and the same will be looked into by the court in the final disposal. But yes. Yes, in RFA.
Now, it is pending for
Yes. Let it go put one court so that it will be. There should not be any multiplicity of the findings recorded by the trial. Yes, sir.
Yes, I am agreeing to
Because what I'm saying, it's not seeking for clubbing. Let it go to the one learned one.
purpose of transfer is always to avoid the conflict.
Correct.
Okay, it is in plaint. In the suit which he wants to transfer it to the other. This plaint is filed only pursuant to the judgment of the trial court. Judgment of a trial court.
In RFA after 32, RFA 32. Yes.
Then no other action. The suit itself will not have it. How we can visualize my right in the other
Sir, whether suit survive or not, dismissal or decreed, it is not under this. So only go to the particular.
Yes, but it is prerogative of the principal to transfer or not transfer.
Yes.
Only stated why he is not trying to transfer. That's all. He is not actually anything more than it.
Correct. He is saying that only cause of action is different.
So there is no cause of action is totally different. Now that's all he said. Now whether the suit is maintainable or not, if you consider whether the respective court is pending, and that court takes the view that it is still maintainable, then even then it will not conflict with the judgment.
Why it can't be done by a very common one judge?
No, because the Russian tendency to be right. So I'm not.
So how it will prejudice you?
Provides that the party is included in litigation. If litigation commences from the date of such inclusion, not earlier. Suppose this is transferred, he will take advantage of this by saying that I am not there. I am not there at all. He can include me in the other suit. So that difference, I will be deprived of the suit.
That may not be done. That may not be valid. Judge, let they be heard by the one judge. Then
may I make one question? Even if it is transferred, I have read the application before I made it.
No, all those things will.
That may be separating. By this
Sir,
transferring code,
totally.
So if you have
So there are two seats, just 1 minute. 5272 of 2011 and 49 of 2011 and 8603 of 2008. Only these three seats. Totally. Please sit down. Please sit down. In this petition, in this is a revision, Allah. In this revision, please sit down. Please. In this revision petition, the petitioner has challenged the order dated 25th February 2022 in miscellaneous number 562 of 2021 on the file of the Principal City Civil and Session Judge at Bengaluru, dismissing the petition filed under Section 24 of CPC. The relevant facts for the adjudication of this petition are that the petitioner herein has filed an application in miscellaneous number 562 of 2021 seeking transfer of OS number 4900 of 2011 pending on the file of the CCH-26, OS number 5272 of 2011 pending on the file of CCH-62 and OS number 86083 of 2018 pending on the file of CCH-62 to the one court. Why you are seeking for 60 for CCH-6? To the CCH-6 where OS number 1321 of 2001 is pending consideration. Full stop. Heard the Lana Council appealing for the part. It is full stop. Perusal of the finding recorded by the trial court would indicate that the father of the petitioner dash Ankanna Reddy died leaving behind the testament dash will dated 39/1992 and as such the petitioner has filed P&SC number 155 of 1998 against the respondent herein. Full stop. The said P&SC number 155 of 1998 on contest by the respondent number 1 was converted into suit in OS number 1321 of 2001 on the file of the CCH-6 and the said suit came to be decreed on 8/9/2010 and being agreed by the same, the respondent number 1 herein has challenged the same before this court in RFA number 32 of 2013 and the said first appeal came to be allowed by this court on 20th April 2021 and the matter was remanded to the trial court for fresh consideration. In that way of the matter, the remaining 3 suits pending consideration before the different courts be heard by the common court was the contention of the petition's hearing. I carefully considered the finding recorded by the trial court, whereby the trial court taking into consideration the fact that the cause of action in the aforementioned 3 suits are different, accordingly held that the aforementioned suits cannot be made available to the common court for final disposal. Having taken note of the finding recorded by the trial court, I am of the view that the said finding recorded by the trial court is incorrect, as the parties to the suit are same and the subject matter of the suit are one and the same. However, the cause of action may be arise in the aforementioned 3 suits are different. However, in the event if these 3 suits along with the OS number 1321 of 2001 as the same was remanded by this court is heard by the common judge in CCH-6, is heard by so and so, there would not be any multiplicity of the finding recorded by the trial court by the trial court in these 3 different suits, which are interconnected with regard to the claim made by the parties on account of the testament, on account of the will dated 39/1992 executed by the father of the petitioner. In that view of the matter, I am of the view that the order dated 25th February 2022 in miscellaneous number 562 of 2021 is set aside and the OS number 4900 of 2011, pending consideration before the CCH-26, comma, OS number 5272 of 2011, pending consideration before the quota number 62, and one more is, and OS number 8603 of 2018, pending consideration on the file of the CCH-62 is withdrawn and transferred to the CCH-6 of CCH-6 is transferred to the Principal City Civil and Session Judge within bracket CCH-6, wherein OS number 1321 of 2011 is pending consideration. That way of the matter, the revision petition is allowed, and the order dated so and so, order dated 25th February 2022, miscellaneous number 562 of 2021 is set aside, and the application filed by the petition filed by the petitioner herein under section 24 of CPC in miscellaneous number 562 of 2021 is allowed. Common and that will be seen. Yes, common and terror. Strike it up. Very well. Yes, sir. No, I don't know. No, that cannot. Just transfer is just. Yes, 72. Yes. Yes, sir. Anyway, it's practicing. What do you require? It's practice. Only when the patients will come, he will come. Whenever the patients will come, he will come. And then, whether is it possible? Anyway, he has put in profession or consider period, because you leave apart the petitioner. Think about the patients who are having belief with this man. Huh? You get it? This was a very considerable, of course. So assessment here correct again. 31st March. Okay. Yes. When a council appearing for the parties submitted that there is a possibility of settlement in the matter. In that way of the matter, this matter, you have first, sir? First September. Yes, list on 1st September. Interim order granted earlier, extended till next date of year. Yes. $60? You are for name? Where were you? No. I think already you were dictators are not represented. Absent at the moment. No. You should have been. Already 10 matters are gone. 73. Yes, at the request made by the Lana Council appearing for the petition. This turn next week, better. Next week after next week. Only Sunwell. So wait for another 10 days. Nothing will. Order of status quo is extended till next date. 2 weeks for 20. Yes.
I am for the petition of lordship.
Yes, sir.
This is a defendant's petition of lordship.
Yes, sir.
The suit filed by the plaintiff for to declare that plaintiff is the owner and possession of the property, and the agreement dated 10/12/2004 is not binding on
Not binding upon. Yes, sir.
The original, your lordship, the agreement has been executed by him in my favor. In 2004, a registered agreement was entered upon. In which your lordship, he has paid the 80% of the amount has been paid, your lordship. Later, he failed to execute the sale deed.
Yes,
in
sir.
that regard, your lordship, my client has issued a telegraphic notice on 26/2/2011.
Yes, sir.
Your lordship, I get it, page 19.
Yes, sir.
Your lordship, after 5-6
Yes,
lines
sir.
onwards, your lordship.
Next.
Then your lordship, what happened? He replied to the said notice.
Yes, sir.
Then what he states, your lordship, in the reply, in the plaint, what he states, in the first week of May 2011, we have given the possession of the property and he has enjoyed the property.
Yes, sir.
Thereafter, your lordship, he filed the suit, now claiming to be that we have interfered in the month of February.
Yes, sir.
As on the date, your lordship, when he gives the reply, your lordship, he states that we have given the possession in the month of May 2011, and
Yes.
we are interfered with the possession in the February 2011.
Yes, sir.
So the antecedent date to the dates are, the cause of action is not corroborating with the plaint.
Yes, sir. Yes, sir.
Again, that on that basis, your lordship, I filed an application, your lordship, order 7 rule 11A for dismiss of the plaint, your lordship. In the meanwhile, your lordship, what I did, your lordship, I have also filed a counter claim.
Wait for another 3-4 months. Anyway, it is already evidence is likely to be completed.
Lordship, now cause of action only, your lordship.
2012 OS. At this juncture, interfering is not correct.
The cause of action itself does not arise, because the cause of action, your lordship, what happens? It is not mere mentioning of the cause of action, but it has to be antecedent to the dates.
Yes, that has to be gone into only in trial. Only in trial, the court has to take some view.
But it is prima facie, it is established in their own plaint, your lordship.
Yes, yes. That has to be considered. That has to be considered in trial. That may be your defense. That may be your defense. This revision petition is filed by the defendant. Defendant in OS number 131 of 2012 on the file of the additional civil judge Davanagere, dismissing the IA number 8 filed by the defendant and order 7 rule 11A read with section 151 of for the sake of parties refer to their rank before the court. The plaintiff has filed suit in OS number 131 of 2012 seeking relief of declaration that the plaintiff is the owner in possession of the suited property, and the agreement dated 10/12/2004 is not binding upon the plaintiff, and as such sought for declaratory relief. The said suit was contested by the defendant by filing written statement. When the matter was full stop, in the meanwhile, the defendant has filed application in IA number 8. The order 7 rule 11 of CPC seeking rejection of the plaint on the ground that there is no cause of action. The said application was resisted by the plaintiff. The trial court, after considering the material required by order dated 22/12/2020, dismissed the application in IA number 8. Feeling good by the same, the defendant has presented this petition. I heard Sri Harish Bhandaril and a counsel appearing for the petition. Sri Harish Bhandaril and a counsel appearing for the petitioner argued that the as invited the attention of the court to the prayer made in the plaint and submitted that the cause of action as stated in the plaint is incorrect, and therefore the plaint requires to be rejected under order 7 rule 11A of CPC. In the backdrop of the arguments advanced by the Lana counsel appearing for the petitioner hearing, I carefully examined the prayer made in the plaint, which reads as under page 20. Undisputably, the suit is seeking declaratory relief against the defendant, and the matter is of the year 2012. List of though the Lana counsel appearing for the plaintiff, appearing for the petitioner's hearing / dependent was justified, saying that that there is a discrepancy in so far as the cause of action is concerned. However, same cannot be looked into in this petition, as the matter is as the suit is at the fag end of the proceedings, and the averments made in the application and order 7 rule 11 is to be looked into only in a full-fledged trial, and in that view of the matter, considering the law declared by this court in the case of Sujata ILR to 2020 so and so, I'm of the view that that it is well established principle in law that the courts, it is the duty of the court to look into the plaint averments alone while considering the application order 7 rule 11 of CPC. Accordingly, the revision fails. 2017 Karnataka. Yes.
But in case of
Yes, sir.
purchase property,
It is now, it is against the dead person.
against dead person, they filed it. Afterwards, when you came to the law, we did ourselves as a
Suit is of the years.
year 2014, no progress. I request Raj.
Sorry. In this petition, petitioner has challenged the order dated 27 June 2022 in OS number 718 of 2014 on the file of the first additional civil judge, Bangalore Rural District, Bangalore. After arguing for some time, Lana counsel C. M. Ashwath Narayan Reddy, Lana counsel appearing for the petitioner, submitted that though the application filed under order 7 rule 11A and B, read with section 151 of CPC came affected by the by order dated 27. However, the suit was filed against the original defendant, and thereafter, the legal representatives of the deceased defendant was brought on record over the petitions in the present revision petition. That way of the matter is submitted that the direction be issued to the trial court to expedite the hearing, in the matter as the suit is filed seeking relief of declaration with consequential relief of permanent injunction. Taking into consideration the fact that the suit is of the year 2014, I'm of the view that the trial court shall expedite the hearing taking into account the circular issued by this court recently with regard to the disposal of the suit of the year beyond 5 years, and I am of the view that trial court shall expedite the hearing and complete the proceedings at the earliest. Yes. Accordingly, revision is disposed. Yes. At the request made by the Lana counsel appearing for the petitioner, next date video. List after 2 weeks, let us. List after 2 weeks. Yes. Yes. Suit for recovery. On the basis of yes. 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 So you received 21 lakhs. According to you, it is repaid. Yes. 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 Only to ascertain as a director of the check or personal capacity. Is one aspect. One aspect. Then
There is timing from the yes, initial to 138 only.
yes.
The evidence also the agreed on certificate and
Partly subject. Anyway, she is already, the cross examination is already. It is in a fag and 2015 suit. 74. 74. Alla? 1 minute. Yes, sir. Paragraph.
Paragraph 3. Last sentence.
I made payment. Oh, yes.
Suggest that earlier first entity solution is not liable to pay. And here over and it personally liable to pay. Therefore, the entire is depending upon the check. The check box is also my lord. That is a filing. And she has said.
But only thing is, based on the deposition in the OS, whether the suit can be rejected under Order 7 Rule 11. It's a matter to be considered by in the arguments. You have to argue. This ground is always it is open for you. So if such being the case, if I agree with you, take for an instance. At the time of the evidence, certain admission will be made. Straight away, Order 7 Rule 11 will file and it will be rejected. Then there is no finality to the suit as such. Maybe she may say that it is true to suggest it. So and so, it is personally liable to pay. Yes. 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 However, take these aspects in the at the time of arguments. Better. One 108. Yes.
Therefore, complaint has been dismissed subsequently they went to suit on the basis of claim check. There is no liability, there is a timing from the
Here, the preponderance of facts. Criminal case is based on the.
They are not challenging.
Maybe true. At this stage, interfere with anyway. You take the advantages for you.
There is a finding from the honorable.
Better to withdraw and with a direction to close this. You take whenever now just you read out the deposition in stated at page 74. Anyway, it is in your favor. Take the advantage of the same. Close the suit on merits rather than. I will say that maybe dispose of at the earliest. Anyway, it's within 6 months, I would say. Ardilana counsel appearing for the petitioner. Okay, very well. Good evening. At the request made by the Lana counsel appearing for the petition. 2 weeks. Not next week, 23rd. Yes, enhancement of compensation. Finally, for enhancement, 22. For trial court's record, I have ordered. At a request made by the Lana counsel appearing for the respondent number 2. Next week, following week after this. 29. 29. That day, get ready. Enhancement of compensation. Even if such been the case, that delay period not entered for interest and Court could have disposed of the petition. Why?
That what has come to conclusion that the delay in reference itself.
Delay in reference 18. 18.3b. 18.3. 18.3. Let us see. Let us will see what he means. Yes. Issue notice.
My lord, I appeal for the petition. Here, my lord, paper publication has to be taken since the respondents are not there.
Yes.
And
But, whether application is filed.
For
File an application.
in this case, directly the court will order for paper publication.
No. You have to file an application. You have to file an application, then the order will be
Now,
passed.
since here, my lord, there will not be any respondents.
I know.
My
For that
court
purpose,
will-
you have to file an application.
My lord, I leave it to your lordship, but in
No, you have to file an application. Even if there is no respondent, I know. In probate, you have to file an application. Based on that application, order has to be passed. You can file it by this week. Better, I can take it up next week.
my lord, there is one more application for dispensation, my lord. Since I have undertaken to pay the highest court fee.
So that cannot be dispensed right now. Let it be there only. Let it be.
Yes.
Let it be. Yes,
My lord,
issue.
in other way, my lord, paper publication may be ordered. I will file application. That also I can.
If you file it, then it will be ordered.
But it's already.
First mother will born, thereafter child.
Yes.
Not child and thereafter mother.
Yes.
You file it application, I will allow.
My lord, kindly have it next week, my lord.
Next week, very well.
The
Next
date.
week. Date. 26, sir. 26. By that time, you file an application.
Yes.
Yes. Yes. But when was the order passed? 8 to issue. Let us issue notice. In addition to that, take Krishna Lana counsel appearing for the respondent BDA, except notice for respondent. Let us switch.
It's already an stay order by
In MF. Issue notice. Yes. Yes, Mr. Notice. Let us switch. Delay will be there. Let us switch. Maybe. Let us issue emergent notice. In addition to that, G. Lakshmishwar, accept notice for respondent B. That cannot be done. At this stage, it cannot. I could have given if it is a 2022 petition. It is 2021 petition. 2021 petition. If it is 22 to recent agire korta ide. Let us. You serve copy. In addition, so except you serve to G. Lakshmishwar and move it at anything. Yes. Rupesh. Yes, Sharad. I request is not there. One more approach. Today is a civil miscellaneous. Sorry. No representation on behalf of the petitioner and a counsel appearing for the respondent 2 and 3 is present in order to provide an opportunity to the petitioner. 2 weeks. 29. Yes, sir. Rajeshwar sir, it may be taken up any other day unless today is a civil miscellaneous day. All CPs and LA day. LA day. Yes. Yes. Unless this short question, so that consideration I can do. What's the prayer, sir? Yes, Mrs. Yeah, no, let us. Mandamus direct. Consider representation. Consider it. Which court will say do illegal? Huh? No court will say do illegal. A short question. Please, short question involved in this petition. Just a minute. The short question involved in this petition is with regard to the consideration of the representation dated 24/5/2022, petition bracket annexure E, made by the petitioner to the respondent authorities. It is the case of the petitioner that the respondent authorities has issued the allotment letter dated 24 June 2006 in bracket annexure A with regard to the site number 169 at Arkavati layout block 21, and in this regard, sale deed ಆಗಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ. And in this regard, absolute sale deed has not been executed by the respondent authorities, despite the issuance of the allotment letter issued in the year 2006. In that way of the matter, earlier allotment was cancelled. This is annexure A was cancelled. Annexure. So now the sale deed has to be executed in so far as annexure D is concerned. Right, sir?
Expired issuance of allotment issued in the year 2006. Arkavati layout block 21.
ಅದರ ಬದಲು B6 Arkavati ತೆಗೆದುಬಿಟ್ಟು B6-SD-2018 ನಾಡಪ್ರಭು Arkavati ತೆಗೆದುಬಿಟ್ಟು ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ layout within bracket survey number 63 and 66 bar A Bhimanakuppe, close the bracket. Though the allotment letter as per annexure D is issued in favor of the plaintiff, in favor of the petitioner herein. However, the absolute sale deed has not been executed, and accordingly the petition has made representation at annexure E and F, and same has to be considered by the respondent authorities. The fact that the aforementioned representations were not attended by the respondent authorities, being the instrumentality of the state under Article 12 of the Constitution of India, I am of the opinion that the respondent be directed to consider the aforementioned representation at earliest within outer limit of 8 weeks from the receipt of this order. It's also made clear that this court has not expressed any opinion on the merits of the case, and the respondent authorities shall consider the representation in accordance with, and outcome of the same be conveyed to the petitioner. Let it be considered. ಮಾಡಬಹುದಲ್ಲ? ವೆರಿ ಗುಡ್. ಅದರ 230 ತಗೊಳ್ಳೋಣ. ಇಟ್ ಇಸ್ 230 ಯಾವತ್ತಾದ್ರೂ LAD ಏನೇ ಬರ್ಬೋದು. 17th ಮಾಡ್ಬೋದಲ್ಲ ಅಷ್ಟರ ಬೈದಿಟ್ಟು. List on 17th at 2:30. Very well. Very well. Sir. Yes, Vasan Kumar. Postmortem. Yes. It could be done. This petition is filed under precedence. Is filed under section 24 of CPC, seeking transfer of MC number 678 of 2021, pending consideration before the third additional principal judge, family court at Mysore, to second additional family court at Bangalore for final adjudication in the matter. Whether you have also filed, which is that? Yes, filed 678. You have filed 4936. First of heard the Lana Council appealing for the parties. It is not in dispute that the respondent herein has filed MC number 678 of 2021 before the third additional principal judge, family court at Mysore, and
my lordship, in that matter, I am appearing for the respondent.
It will be transferred better. Better it should be.
The matter is already posted for. For me, 151 application. I have filed 151 application stating that the club the matter if Mysore and Bangalore case ಅಲ್ಲಿ stake ಇಡೋದಕ್ಕೆ ನಾನು apply ಮಾಡಿದ್ದೀನಿ. Family court ಇಬ್ರು ಕೂಡ section. ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಸೆಕ್ಷನ್ 9 ಅಲ್ಲಿ ಇಬ್ರು ಕೇಸ್ ಹಾಕೊಂಡಿರೋದು. ಸೆಕ್ಷನ್ 9 ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಇಬ್ರು ಸೆಕ್ಷನ್ 9 ಅಲ್ಲಿ ಕೇಸ್ ಹಾಕೊಂಡಿರೋದು. ಹಾಗಾಗಿ ಇದನ್ನ ಸ್ಟೇ ಈ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಆದ್ರೆ ಇಬ್ರು ಒಂದಾಗ್ತಾರೆ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ ಮತ್ತೆ ಇಲ್ಲಿ ಇಬ್ರು ಮತ್ತೆ ಸ್ವಾಮಿ ಅಲ್ಲ ಮ್ಯಾಟರ್ ಸ್ಟೇ ಆದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್
ಸ್ಟೇ ಏನಿಲ್ಲ. Only final disposal in this case.
My lordship, I have filed 151 application for the stating the family court Bangalore case to stay the matter in that.
No,
kindly
not,
please.
that cannot.
And ಮೈಸೂರಲ್ಲಿ ಸ್ವಾಮಿ ಇದು ಆಲ್ರೆಡಿ ಕ್ರಾಸ್ ಆಗಿದೆ, ಪಾರ್ಟ್ಲಿ ಕ್ರಾಸ್ ಆಗಿದೆ. ಇಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ.
Yes, MC number 2007 seeking restitution of conjugal rights. It's also forthcoming from the petition papers that MC number 4936 of 21 is filed by the petitions herein against the respondent seeking restitution of conjugal rights. Ibru restitution of conjugal rights, but jatel illa. Heard the Lana Council appealing for the parties, but taking into consideration the hardship that may be caused to the petitions herein, as the petitioner is the resident of Bangalore, and therefore, following the law declared by the apex court in the case of
my lordship kindly
so and so reported in 2016 14 SCC 356. I'm of the opinion that the MC number 678 of 2021 pending consideration before the third additional principal judge, family court at Mysore, is withdrawn and transferred to the second additional family court at Bangalore for free.
My lordship is on submission ಇದೆ. My lordship on submission ಇದರಲ್ಲಿ ಆಲ್ರೆಡಿ ಮೈಸೂರಲ್ಲಿರೋ ಕೇಸಲ್ಲಿ ಕ್ರಾಸ್ ಆಫ್ PWM ಪಾರ್ಟ್ಲಿ ಆಗಿದೆ.
Maybe true. Let it be transferred. Yes. No representation on behalf of the petitioner. Just after 3 weeks. Any other day? Ready? Any other day in stock? Yes, 2:30. ಹೇಳಿದ್ರಿ. Today you see your serial number is at 91. ಎಷ್ಟಾಗಿದೆ ಮೇಡಮ್? Huh? 20 disposal, 21 disposal is also there. See, mere not ಇದು instead of that. ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಎಲ್ಲ ನಾವು ಹೇಳ್ಬಿಡ್ತೀವಲ್ಲ ಡಂಪ್ ಆಗ್ಬಿಡ್ತದೆ ಅಲ್ಲಿ ನಮ್ಮಲ್ಲಿ. ಎವ್ರಿ ಡೇ ಮಿನಿಮಮ್ 10 to 15 ಮಾಡಲೇಬೇಕು. That is there in my mind. Sitting as a learned judge of this court, I think I have to and should be satisfied by both the parties ultimately. Sorry. ಯಾವತ್ತು ತಗೊಳ್ಳೋಣ? ಒಂದು ಓಕೆ ಯಾವತ್ತೇ ತಗೋಬಹುದು? ನೆಕ್ಸ್ಟ್ you have already see 16. What has happened in August? 15 working days, 15 holidays. Huh? Not ಬಟ್ ಲ್ಯಾಬೊರೇಟರಿ ವರ್ಕ್ ಆಗ್ಬೇಕಲ್ಲ ಅಲ್ಲಿ ನಮ್ಮಲ್ಲಿ ಆಫೀಸ್ ಅಲ್ಲಿ ಇದು ತಗೊಂಡಿದ್ದು. ಇಲ್ಲಿ ವರ್ಕ್ ಆಗ್ಬಿಟ್ರೆ ಆ ಲ್ಯಾಬೊರೇಟರಿಲಿ ಫೈಲ್ ಅಪ್ ಆಗ್ಬಿಡ್ತದೆ. ಯಾವ್ದು ತಗೊಂಡು? 25th. ಅಲ್ಲ, ಇಫ್ ಇಟ್ ಇಸ್ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಐ ಕ್ಯಾನ್ ಟೇಕ್ ಇಟ್ ಅಪ್ ಅಟ್ 2:30 ತರ ಒಂದು ತಗೊಂಡು ಅವಾಗ ತಗೋಬೋದಲ್ಲ? ಎಷ್ಟು? 25th at 2:30 ಬೆಟರ್. 2:30 ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಇಟ್ ವಿಲ್ ಬಿ ಟೇಕನ್ ಅಪ್. ಅದಕ್ಕೋಸ್ಕರ ಹಾಕಿ 25th 2:30 ತಗೊಂಡು ಎನಿವೆ 2:30 ಅಷ್ಟೇ ಅಲ್ಲ ಮೇಡಮ್? Yes, madam. Yes, madam. Yes, is passed over one. Yes, one matter, Pune. How is Pune? Barodila, you see, this court can. This court can transfer the case to the any other state. Cannot. Only Supreme Court can do. Because the reason is that court is not subordinate to me. Sir, irbodu. Supreme Court can do. See, any other court in Bangalore, sorry, in state of Karnataka, this court is having jurisdiction. Outside, I can. Illa madongilla actually. Madongilla, sir. Madongilla. No. Territorial jurisdiction is there. Territorial jurisdiction.
There is no bar.
No. Recent this court, I think there is a recent judgment when we Supreme Court or the recent judgment. Yes. 23. Anyway, just have a look. Yes, correct. Where such courts are subordinate to different courts, the application shall be made to the High Court.
The courts are subordinate to different high courts.
Subordinate to different high courts. Where such courts are subordinate to different high courts, the application shall be made to the High Court in which a suit is. This court, I think it's recent on the no, one thing I will examine. That judgment. Better. Instead of let us use date for him next week. Next week it will be 17th. LED is better. 18. Let us will see. Recent. Yes, sir. Looking at because 24 recent judgment, the very same. About 23-3. Yes. So, madhyana division bench ಇದೆ. Division bench ಮುಗಿಸಿದ
சொல்லுங்க. ஏஜி ஆபீஸ்ல கேக்குறாங்க. ஓகே ஓகே ஓகே. Announcement of order.
Please, my lord, appear for the petitioner.
Yes.
Number 1. Repeat interim.
Divisions petition stand dismissed.
Number 2. CPN Rajeshwar.
You heard the Lana Council appearing for the parties. I am of the view that I do not find merit in the arguments addressed by CP and Rajeshwar, Lana Council appearing for the petitioner. Accordingly, petition is dismissed. However, it is open for the petitioner to approach the respondent BDA with cogent documents to establish his right over the schedule property mentioned in the writ petition. And in such event, the respondent BDA shall consider the same in accordance with law. In the result, petition stand dismissed. No, that cannot be done. Petition is completed. Here, Linga. Petition is dismissed.
Number 4.
Writ petition 9937, 9938, and 9939 of 2022 are allowed and impugn notices dated 21st August 2019, and further proceedings thereof are passed by remanding the matter to the respondent revenue to reconsider the issue afresh in terms of the discussion made above. 2. Writ petition number 9945 of 2022 is allowed, and the order dated 3rd May 22 passed in appeal number C80 number so and so is passed. The respondent number 1 shall reconsider the appeal filed by the petitioner referred to above and to dispose of the same in accordance with law after providing an opportunity of hearing to both the sides, considering the observation made above. WP number 9946 of 2022 is allowed, and proceedings initiated under section 153C of the Act culminating in issuance of the notice dated 22nd October 2009 are passed, and further proceeding thereof are passed by remanding the matter to the respondent revenue to reconsider the issue afresh in terms of the discussion made. Total.
93 with Jagdish Chari.
230. Yes, sir. Yes, sir.
Regulate applications.
No.
And it, public action.
Yes,
And it, as per the,
you have participated. Yes, next.
you have kindly submit, participate. Kindly submit this election here.
Yes.
Yeah. Take number 10.
Yes, yes. Yes. So dimension says 77.5.
I like to inform you that the sale of the above site part is to offer the highest bidder at the time of action, sale of shop, residence, residential, inter site, and on 589. We confirm your name. You are therefore required to pay the balance amount of notice under column number 4 within 45 days from the date of receipt of this intimation that you are not.
Yes.
Site number 291, and you have 7752. You have square meter.
Yes, sir.
Second, total 1,750.
Yes, yes.
Total comes to 1,39,006.
Yes, sir.
Next, amount already paid by you initial deposit of 35,000. Balance due to pay this one.
Yes, next.
Next, it is very important. On the payment of full value, you are required to execute an agreement after which possession certificate
Will be issued. Yes.
Failure to pay the amount within prescribed time will entire transaction of the sale of the site and deposit made by you will be perfect subject to the authority and site.
Yes.
These are the conditions. Well, last minute, as per minute, I fulfill.
So agreement was entered into. Agreement was entered into.
Yes.
Annex shall be next.
Annex shall be the agreement.
Next. Next still. After agreement, what has happened?
After agreement, you are last minute sale agreement. You are annex to be.
Correct.
You are last minute. And you are last minute instead of minute. This minute, A is the minute condition. Condition. You are last minute. 77 by 2.
Yes, yes, correct.
It's a public action.
Yes, correct.
Not minute or ordinary. You are last minute. Second, you are last minute annex B is the same. He cannot say it. Not minute the same. Same.
So according to you, it is sale deed. Next.
Page 16. 16. Total is 78 square meter. Instead of 77 minute.
You made it 7350. Yes. Correct.
You are last nowhere stated in the saying reduced to reduce from 7. You are last Alexa B reduced to 73.58 from 77.5.
Correct.
Nowhere stated in the saying without notice to me.
Yes.
First of all, no notice.
Yes, you should have been heard.
Nowhere stated in
Next.
reduced to 77.4.
Next.
No notice. Come on to minute.
When was the agreement? This was
agreement.
That was in 19th June 1992. 19th June 1992.
10 June 10/9. You are 10/9.
Then typed copy note. Typed copy done. Typed copy 19th June ಅಂತ ಹೇಳಿದ್ದಾರೆ. 7th July 1992. 7/7/92. So it was in your knowledge by 1992.
No. When I should be working by you are not
No, anyway, yes, anyway, you signed it. Delay.
In a agreement on trading, no other state is so far as they used to 7752.
It is stated ನೋಡಿ 735258 ಅಂತ ಇದೆ. Page 16 ಅಲ್ಲಿ.
No reason given.
Need not pay.
No reasons given.
Not necessary, it's auction. It's only an offer until the completion.
No, not allotments.
Even if auction is public auction is also an offer unless it is confirmed by way of a sale deed. Even they have a right to even cancel it also. That's a law established. That's one aspect. Second aspect, though it is known to you in the year 1992, you are challenged now.
From 1990, from the date of agreement, no notice.
Why ಬೇಕಾಗಿಲ್ಲ notice ಬೇಕಾಗಿಲ್ಲ. They need not ask you also for this. That's a settled position. And you have signed it also. Signature of the first party. Not a case. Third is third. Delay is there.
I will give you one citation on the basis.
Kodi.
Promissory estoppel.
ಬರೋದಿಲ್ಲ. Promissory estoppel will not come here.
No, you are asking that this is public action, not public action. Don't even go.
Sir, there is only a proposal.
Not proposal, confirm. Not proposal, confirm.
Yes, next.
It is not confirm. It is not proposal. Confirm public action.
ಇಲ್ಲ.
It is not. It's not even that enactment of site.
Yes, sir.
Public
Next.
action. It's the amendment there.
Sir, it was in 1992. Now your challenge in 2017 that cannot be.
I tell you that 700 implementation.
Maybe.
You are not, now right, my prayer, you are not signing my prayer.
Yes.
My prayer. First prayer, you are not, that is okay. You are not, one you are not, all for the reports.
Yes, sir. It will be considered. Yes.
My representation, the times in my representation.
Let they will consider. Yes. Yes, yes, I have. Yes. 45 I have. Yes. ಓದ್ಬಿಟ್ಟಿದೆ ಬಿಡಿ. ಎಸ್ ಕೊಟ್ಟಾಗ ಫಸ್ಟ್ 77 ಅಂತ ಹೇಳಿದ್ರಿ, ಇವಾಗ 73. ಲೆಟ್ ದೇ ವಿಲ್ ಕನ್ಸಿಡರ್.
One submission, you are not coming with objections.
Yes, yes. Yes, sir. Yes, sir.
It's a bit like that in the action we are done.
Relevant line go to. No, full court is there at 345. Tandrele, please go to relevant line. Statement objection ನಾಳೆವರೆಗೂ ಓದಬಹುದು ಬೇಡ. ಸೊ ಅದಕ್ಕೋಸ್ಕರ we complete it. No. You complete. Yes, yes. ಇಲ್ಲ ರೆಲೆವೆಂಟ್ ಲೈನ್ ಎಲ್ಲ ಓದೋದ್ ಬೇಡ. ದೊಡ್ಡ ಪ್ಯಾರ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು ಕೃಷ್ಣ ಅವ್ರು, ಗೊತ್ತಿಲ್ಲ ಸರ್. ಸಣ್ಣ ಪ್ಯಾರ ಮಾಡ್ಬೇಕು ನೀವು ಇಂಥ ಕೇಸ್. 6 ಲೈನ್ ಹೇಳಿ. Yes, you deposited auction your next day.
Action of deposit was confirmed on 1689.
Because the balance title value within 45 days as per the rule 63. Next. Yes.
Disposal of car side.
Yes, yes.
And commercial side and other
rules. Yes.
That's another item.
Let they will consider.
One minute. Presentation direct consider. Whatever it is, you are last by the video.
Yes.
Same like that, you should
Not yes. Not a case for interference. Sorry. Not a case for interference. Not a case for interference. ಇನ್ನೊಂದಿದೆಯಲ್ಲ? ಇನ್ನೊಂದಿದೆಯಾ? Yes, Gurudev sir can be taken up any other day. What is the matter? Just you want to say something? Yes. RPS in why it was in so far as why it was yes. No, that's next you seek it. Whether you are working. Yes, I know him. No. Next. Four children are with you.
And when they were so small, my God, 2 years, 3 years, and this man was arrested, all people were sent to United. 1 second. Exactly. I mean, because the recent development this my client has lost its job also. You are working as a temporary. This is a memorandum which has been issued.
Yes.
So it's ಸ್ವಲ್ಪ argument ಮಾಡಬೇಕು. ಯಾಕಂದ್ರೆ ಸೆಲೆಬ್ರೇಟ್
ಹೇಳಿ ಹೇಳಿ.
4 ಜನ ಮಕ್ಕಳು ಇಟ್ಕೊಂಡು
ನೆಕ್ಸ್ಟ್ ಹೇಳಿ ಲೀಗಲ್ ಇಶ್ಯೂ ಬಗ್ಗೆ ತಗೊಳ್ಳಿ ಜಸ್ಟ್ yes.
I give a copy also. I also tell. I also need this.
Yes, sir.
What she has taken.
So now you attend the age of superannuation. Where were you working, sir? So you are entitled for pension. Pensionable.
She has paid.
Pensionable. Pensionable job. Allah. Yes. Yes.
ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಹೇಳ್ತೇನೆ. ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನು ಪ್ರೈಟ್ ಮಾಡಿದ್ದೆ ಅದರಲ್ಲಿ 498A
ಅದೆಲ್ಲ those things.
State rules and CBC did.
Yes.
And same grounds, and then there has been applicated. Same, they have taken full grounds and they are not challenged it. So
I've seen.
My point is that he is not now working. He has to take up one makal in Madhya Pradesh. He moves jana makal in that. One is studying in degree, another studying in PUC, another is fortune. Then the second no mad. And now.
So now you are working as a. It's a home guard is a daily wage.
Daily wage. Temporary income.
It's also temporary. Sailing together. Then I shall consider.
And also, there are one more solution.
No.
This is not the paid money of the argument money there. But in the period of paid money, on the net. That is the asset and liabilities for the Kurta. The asset and liabilities 50,000, but on the period of money that she is working, the period of 40,000.
Okay. Sorry. Will be considered. Born in 2015. What the video? Sorry, hard and reserve. No, 2015. 2015, but born single. Human dignity has to be looked at.
So each and every case circumstances change.
Very well.
It's not that one case only. And that which I will not see the only on the side of one.
Correct.
Please. You have to see on the side of the husband also. Nowadays, you have to see. So the other side, if they are 125, you have to pay. This is a very peculiar case which I am not making.
It's a good case for passing good orders.
ನೀವು ಸ್ವಲ್ಪ ಏನೋ ಡೈಟ್ ಕೊಡ್ತಿಲ್ಲ ಹಾಗೆ ಮಾಡ್ತಿದ್ವಿ
ಮುಗೀತಲ್ಲ ಸರ್, ಮತ್ತೇನು ಇಲ್ಲಲ್ಲ?